Tonight's program is part of a series that we launched in the fall of 2012 called Fordham at the Forefront. And our goal is to highlight our best and brightest faculty to showcase Fordham's work in areas of universal concern and importance. Tonight, the topic, of course, is political behavior. And now it's my pleasure to introduce our distinguished speaker, Zephyr Teachout. Copies of her book, Corruption in America, From Ben Franklin's Snuffbox to Citizens United, are available for sale at the door on your way out. So Zephyr is an associate professor of law at Fordham University. She served as the first national director of the Sunlight Foundation, a non-resident fellow at the Berkman Center for Internet and Society at Harvard Law School, and as the director of Internet Organizing for Howard Dean's 2004 presidential campaign. Zephyr has her BA from Yale University and a JD and MA in political science from Duke University. So we're thrilled to have you with us this evening, Zephyr. The floor is yours.
Thank you. It's a delight to be here. Fordham has been extremely good and warm and welcoming to me, and I've had a wonderful experience with the students. I finally got to teach night school at law school. I know there's some night school students here, which was great, and I'm going to do it again next year. I teach property and election law at Fordham, and a new course that I'm developing on market structure and democracy, looking at antitrust and its relationship to democracy. And then next fall, I'm teaching a course on prosecuting private and public corruption. So, if you know any interesting guest speakers,
they're not available.
What I'm going to talk about tonight is I'm going to use this opportunity to talk about a book that I came out with a few months ago, Corruption in America. It is not a history of all of corruption in America. If it were, I would never have come out of my cave. Rather, it's an exploration of what corruption means in law. So think about, corruption's a word we use all the time. You might use it in passing at dinner table or talking to somebody, but really think about if you're sitting on a jury and had to decide whether a gift given with intent to influence was given corruptly or not. That's an element of a lot of bribery law statutes. So the question this book tries to answer is, what has corrupt or corruptly meant in American law over different times in our history? And the impetus for the book actually came about a very long time ago. It did take me several years to finish this. It came about in 2007. After Justice Sandra Day O'Connor left the court, there was a Supreme Court decision in which Justice Roberts, in the majority opinion, the opinion wasn't really about the definition of corruption, but it was a side issue. The dissent had said corruption includes influence, access, and when those with public power use it for private ends. And in the majority opinion, Justice Roberts said, corruption is quid pro quo. Enough is enough, to the dissent's description. There's a real impatience in it. It's really interesting that Roberts was sort of going out of his way to say, what are you even doing talking about corruption in this broader way? And I got interested in this case, and this is before I was an academic. It actually formed the basis of my first academic job, which was at Duke. So what does corruption mean in law? What has it meant? And even at the time, it was very clear that the implications were going to be huge. That depending on how the court defined corruption, it would either uphold or strike down a whole series of reforming laws related to campaign finance. This is because of a framework that's been in place in American law since 1976, since Buckley versus Vallejo. And ever since Buckley versus Vallejo in 1976, the Supreme Court will look at any kind of campaign finance law by going through a two-step process. First, it will ask, does it implicate First Amendment speech interest? Is there ways in which this money in politics that is being limited is spent for political ends that implicate your First Amendment rights? And if the answer is yes, the court will strike it down unless It is narrowly tailored to serve an anti-corruption interest. So if it implicates your First Amendment, for the non-lawyers here, you can just shut off your brain for a second. We can come back to this in question and answer. But if it implicates the First Amendment, you can uphold it if Congress or a state house passed it to serve anti-corruption ends. So suddenly it really matters what corruption means. Because if corruption has a narrow meaning, only a few laws will be upheld. And if corruption has a broader meaning, then a whole set of reform laws will be upheld. We saw the implications, these implications play out in Citizens United. So I got interested in this, and I decided to start, in the first third of the book, is really looking at the Constitutional Convention. And I should tell you right off the bat that I am not a Justice Scalia originalist. I think of myself more as a Langston Hughes patriot. So Langston Hughes, in a beautiful poem that you may know, says, "Let America be America again. Let it be the land the dreamers dreamed. America was never America to me." And he goes on to sort of juxtapose this vision and the absence of this dream actually being realized. And so when I say I'm a Langston Hughes patriot, what I mean is that, like the Hughes poem suggests, I believe that there's a real power in the best parts of our history that we should go, the best dreams of our history, and that we should go learn from those dreams. But also, like Hughes, I don't think we should be sentimental and think they had more wisdom than any other people in human history. So America was never America to me. It's not like the founders got everything right. They got race wrong, they got sex wrong, they got a lot of things really wrong. So, but having said that, I think there's some real wisdom in the creation of our Constitution, and I want to pull that wisdom out. So I was really interested in what happened at the founding during the Constitutional Convention. Well, it turns out at the Constitutional Convention, there was something close to an obsession about corruption. They talked about corruption more than they talked about violence or factions or almost anything else. You can see James Madison in longhand writing out corrupt or corruption 54 times in his notes from the summer, convention that summer. And they talked about corruption all the time because they were anxious. They saw, well, look at England. England had the basic structure right, but it was torn up by corruption. So as Patrick Henry said, England had the finest fabric that human nature has ever reared, but it was rent by corruption. So we want to then build a society taking the wisdom of England, but protecting more than they have against the threat of corruption. And so in the convention, having decided to have a national government, the real question was, how do we build it in a way that will lead those in public power to serve public ends instead of to serve private or narrow ends? And when they talked about corruption, they were not talking about quid pro quo bribery. We know that, first of all, because quid pro quo doesn't enter the bribery lexicon until the 1970s. Second, because there were no bribery laws that applied to lawmakers. There are bribery laws that applied to judges and to the executive branch, but weren't bribery laws that applied to elected officials. They just didn't exist. So when they talked about corruption, they were talking about more the orientation of the spirit, whether those in the executive or legislative branch would be oriented towards the public or narrowly, selfishly, corruptly oriented towards themselves and their friends. One of their biggest fears was what they called the problem of placemen. So placemen were those who went into elected office in order to get really good deal from the king. This is looking at England. So basically you'd get elected, and then instead of representing your borough, you'd get this great job from the king, and therefore serve the king's interest instead of serving your borough's interest. I, of course, think we have a modern problem of placemen with people who go into elected office in order to later serve lobbying interests, as now over 50% of congressmen and women become lobbyists after leaving office. So they're not serving their boroughs, as it were, but rather serving their other masters. So this problem of placement was talked about day and night, and eventually the provision of the Constitution, which we now have, which Mason called the cornerstone of the convention, says that you can't hold elective and appointed office at the same time in order to prevent against this. The title of the book, Benjamin Franklin's Snuff Box, comes from another provision of our Constitution, a provision that forbids accepting a gift of any kind whatever, this kind of petulant, First Amendment absolute language, any kind whatever, from a foreign power. And this came from, the derivation is really interesting. It originally comes from the Netherlands, where it was made fun of as being so purist. Like, who do they think they are? Plato's Republic, as international scholars said at the time. But it made its way into our Constitution after Benjamin Franklin accepted a diamond-encrusted snuff box from the King of France, a gift. And there was a concern that that gift, there's no deal, no quid pro quo, no exchange, that gift would then corrupt Franklin. That Franklin would then think, perhaps too generously about France when, French commercial interests, when he actually should be oriented towards American interests. I think it's important because it shows how strict they were and how serious they were about really redefining what was considered not corrupt in England and France. Because not only was that not corrupt, that's what everybody did. And then redefining it as corrupt to create and to really try to discipline our new American republic. So one of my favorite characters at the convention is actually Franklin, because he became one of the biggest anti-corruption advocates at the convention, but he was known as that corrupt old fox, and the most corrupt of all corrupt men. He was the oldest delegate to the convention, and I actually think that he represents this kind of way in which American experience, this lack of naivete, the fact his own experience made him actually more strict on corruption because he'd seen so many parts of the world and the way in which it could creep into different systems. So I'm going to read a little bit from the book. In the early spring of, and I might get some more water actually.
Okay,
thank you.
Yep.
In the early spring of 1787, Benjamin Franklin, 81 years old, wrote an old friend from France about pigeons, lightning, mutual friends, and the art of ballooning. Showing off both his enthusiasm and his sense of a declining body, he wrote about his dream of having a French balloon that was large enough to lift him, being led by a string held by a man walking on the ground. Thank you. Franklin, as ever, believed in the possibilities of progress, but wanted to be sure that his flights into electricity, politics, and air travel were grounded. A little more than 6 weeks after writing his letter, Franklin attended the opening of the American Constitutional Convention, not carried by a hot air balloon, but carried on a sedan chair because he was too weak to walk. He was not only aware of his own body's degeneration, rather he saw how the body politic could degenerate if given a chance. His first speech was his major contribution to the convention, was about money and power and politics and the inconsistencies of the human heart. He actually was so determined to get this speech right that he wrote it down and had somebody else read it out loud. And what he wanted to focus on was how we needed to structure systems, and he was desperate. How we needed to structure systems such that people would go into public office and as much as possible maintain the public orientation. And he wasn't naive about it. He knew that we carried within our hearts these different possibilities. So it was the job of structure to pull out of us the positive public-facing possibilities and to make less likely those selfish possibilities that lie within all of us. There's a lot of talk about temptation and how people can be tempted, and how the job of structures is to remove those temptations, take the temptations out, because we're weak. And so let's build those structures. So that temperament, that Franklin was sort of pessimistic about the country. He thought it could last a couple hundred years maybe. But I think that temperament is actually an important temperament, a deep pessimism combined with a deep optimism, and that actually can lead to the greatest possibilities of democracy. So what happens? This new country is built on this anti-corruption principle, is what I argue, that there's something so embedded in the Constitution that you can argue that it's a principle like the principles of federalism or separation of powers. And almost immediately we get in trouble with trying to understand how corruption fits with law. One of the great early cases is a land speculation case. where the people of Georgia, the legislature of Georgia sells land, the Yazoo lands of western Georgia, for pennies on the acre. It's been called the real estate deal of the millennium. I know some people would say that there's New York City deals that might rival that. But it's an amazing deal, and all but one of the lawmakers have a direct financial interest in the sale. They have stock interest in the sale. Because the companies that wanted to buy the land went around to all the lawmakers and gave them stock. So the people of Georgia are not very happy about this. Remember, there are no bribery laws, so nobody is prosecuted because there are no bribery laws. So what do? They kick out every single lawmaker. Imagine doing that now. So the next election comes along, they all get kicked out. They say this is a corrupt law. It was passed through corruption. And just in case anybody's not clear about the status of the law, they hold a bonfire in Atlanta, burn the law, and say this law never happened. We never gave away that land. But the legal question remained. Was the sale of the land a contract that could be abridged or not? This becomes a national debate. You're either pro-Yazoo or anti-Yazoo. So for 10 years this goes on. Do the speculators, who then quickly, the land companies sold the land to speculators, right? Do the speculators actually own the land, or do the people of Georgia own the land? It goes to the Supreme Court. Justice Marshall, himself a land speculator. And it's I believe, very important Supreme Court oral argument, because it is the only oral argument that I know of where they had to pause oral argument because the lawyer for Georgia had to sober up.
I like him already.
Georgia did not win. Justice Marshall says, well, it seems like corruption has crept into our young republic, but how am I to tell the difference between this law that was passed through corruption and another law where just one lawmaker was bribed, or 3 lawmakers, and what kind of bribery? So immediately there's this question about whether a law can basically be so corrupt as to be not a law, and he says no. Another really interesting, this question persists actually for several hundred years, and there's still questions about whether corruption can undermine the legitimacy of a law in the takings clause area for you property geeks. Another great legal question that returns, that is very alive for 120 years is, when are lobbying contracts so corrupt that they can't be enforced? And the basic answer for the better part of a century was that the lobbying contracts are just corrupt. Lobbying was a felony in Georgia, a felony in California, but for the most part, again, criminal law plays a pretty small role in American life. The way in which we know that lobbying contracts are corrupt is through contract law. So there are a lot of contracts, most contracts you can enforce, but there are certain contracts where you can't enforce because the underlying thing is not sellable, like sex. In most states, you can't enforce a contract for sex. You can't enforce a contract to sell your Metro card, right? You can own your Metro card, but it is not a sellable thing. Make sense?
Yes.
You can't enforce a contract to sell organs, for the most part. So lobbying, personal influence, you couldn't sell. You could sell being a lawyer, drafting things, but you couldn't say, I am for $500, I'm going to go use my personal influence to convince this lawmaker. And the argument courts used is that was sellable, it was fundamentally corrupt. So this old man, again, this goes all the way to the Supreme Court, old man from Virginia is owed thousands of dollars by the US Congress, legitimately owed it, but he's too weak to go to Washington. So he hires a lawyer, Boston lawyer. The Boston lawyer goes to Washington, uses his personal influence, meets with people, gets the thousands of dollars, goes back to the old man. The old man says, thank you very much, and I am not going to pay you because that was corrupt contract law. So the Supreme Court has to decide whether or not to enforce the contract, and decides not to enforce the contract. There's no evidence of bribery in this case, but, as the court says, if we're allowed to allow this contract, well, the great corporations of our day will hire adventurers to plead their case in the state houses of the country, and every right-thinking man would denounce that as corrupt. So that's the law of the land until the early 20th century. There's some other really fun, difficult questions in corruption law, namely once we start actually enforcing bribery law, what is corruptly? And for the most part, we allow juries to decide that. But what you see throughout, really up until 1976, is a fairly consistent view that corruption is not, as you can see from these examples, corruption isn't just quid pro quo bribery. Corruption is something that we understand. Laws against it may be hard to pass, but the disease of corruption is the disease when those in public power use that public power for selfish or narrow ends. That starts to change in Buckley versus Vallejo, but really changes in that 2007 case I was talking about, and then 2010 with Citizens United, where the Supreme Court is very clear that corruption is quid pro quo and nothing else. And then 2 years ago in McCutcheon, or is it just last year? Last year, McCutcheon versus FEC, the Supreme Court, in fact, cites to a criminal law statute to define corruption. Does that make sense? So you have this, but when I say the Supreme Court, this is still a battle royale. It's 5 members of the Supreme Court against 4 members of the Supreme Court. So this is a highly, highly, highly contested issue. So in a lot of ways, I wrote this book to the conservative justices of the Supreme Court and to Justice Kennedy. It really started as a letter to Justice Kennedy to say, Justice Kennedy, if you are going to claim the mantle of originalism, if you are going to claim that history is on your side, then you might have to overturn Citizens United. Because your definition of corruption, this quid pro quo definition, just doesn't actually make sense as a matter of American history or law. I also think it doesn't make sense as a matter of American democracy. I told a few of you this earlier, but I was kind of delighted because a mentor and friend of mine, Larry Lessig, gave a copy of the book to Justice Scalia, and I know because I saw the picture. And I inscribed it to our shared love of the wisdom of the founding era. But also, I mean, there's another sort of argument and point in the book, which is not just to the justices. And I want to make one point. I do make some arguments, which I'm happy to talk about why there's this shift, why the judges, why the judiciary changed its mind in some ways. And one argument I actually make is that this is the least politically experienced judiciary we've ever had, a Supreme Court we've ever had. Actually, 1976, when Buckley versus Vallejo was decided, we briefly had a court with people with no political experience. Buckley versus Vallejo is decided, and then Sandra Day O'Connor joins the court. And it's only after Justice O'Connor leaves the court that we see these series of cases where the court says corruption is quid pro quo, corruption is quid pro quo, nothing else. And I think that part of what is driving Kennedy and others is a real naivete, a lack of understanding of how politics actually works, a lack of understanding of the way in which a campaign donation, or in the case of Citizens United, outside spending can corrupt even if there's no explicit quid pro quo, because none of them have had political experience in the way that our justices traditionally have had. But it's also a book or a plea to ourselves, because I think sometimes there's a tendency to think of, less so now, but to think of corruption and fighting corruption as sort of a post-Watergate reformer era movement. And my argument is that it's not just post-Watergate, it's foundational, it's fundamental, it's who we are in some sense. As Hughes says in that same poem, out of the rot and ruin of our gangster death, the rape and rot of graft and stealth and lies. He's talking about corruption. We, the people, must redeem the lands and the cities and make America, America again. And I promise you, America will be. So I think that we have to understand that some of the best parts of our own history, long before Watergate, long before the modern Federal Election Commission, is this real vigilance against the corrupting tendency in politics. I sometimes think of politics as a kind of whack-a-mole. That as opposed to democracy being the inevitable end of society, rather it's a constant struggle that requires constant vigilance. And that vigilance is part of our best parts of our heritage. So my hope, and there's things that we can do about it. Despite the fact that the Supreme Court has shut out in Citizens United and McCutcheon versus FEC the capacity to do a whole series of things which I think are necessary and important. Basically, the Supreme Court has said if it's not related to quid pro quo, you can't pass that reformer law if it implicates the First Amendment. Despite that, there's a lot that we can still do. We can pass, for instance, public financing laws like we have in New York City. Even this court has upheld that as not conflicting with the Constitution. And as a former candidate, I can tell you I wish we had public financing when I ran, because you can feel, even in the brief 3 months that I ran, calling people to raise money 30 hours a week, you can feel very quickly how corrosive and corrupting our private financing system is, and how it transforms our current politicians into beggars and vessels for the wealthiest interests. So a public financing system is possible. I actually think a public financing system might be more important than a constitutional amendment in terms of actually changing the structures of power. And the other thing which I'm really interested in is this old idea Jefferson supported. Jefferson wanted an anti-monopoly clause in the Constitution. But this old idea that a concentrated power is a real threat to democracy, not just to our markets. It's also a threat to our markets. So I support, for democratic reasons, reviving the antitrust laws that we had in place from the 40s until the early 80s. Basically, since 1981, for all intents and purposes, and the antitrust lawyers among you are free to disagree, but we haven't had real, meaningful, robust democratic antitrust laws. And so we've seen this radical concentration in area after area after area. And I think of antitrust as a key campaign finance reform tool, as Teddy Roosevelt did, by the way. So I argue for both public financing and antitrust, and saying that my hope is that lawmakers will quickly act to pass public funding systems and anti-monopoly laws to protect our civic culture. I sometimes feel like our country is both young and old, like the 81-year-old Franklin floating in his hoped-for air balloon. We are in many ways inside his magical experiment, and it has been every bit as extraordinary as imagined. It has brought people to levels often dreamed of and rarely achieved, where they live together in peace, exercising collective power over their own lives. I have no doubt this represents one of the greatest achievements in human history. But democracy without constant vigilance against corruption is an unstable, unmoored thing, subject to great gusts of whimsy and likely to collapse. There's no one walking below holding the string. We need obstacles, restraints, an unbreakable connection between the public and the representatives. Thanks for listening, and I look forward to your questions.